Welcome to everybody. I'm Mark Gilfix, this is Michael Gilfix, and we're here to talk about a critical subject, and that's planning for high net worth families and how to protect all that you've earned. And high net worth is a relative term, to be clear. What we might consider high net worth in the Bay Area is very different from what high net worth is in different communities. So you might not think of yourself as high net worth, but you might fit in this category. And what we're going to talk about here today can truly save millions of dollars over multiple generations, and it is extraordinary what we can achieve. And I think it's important to think about where we are today.
Yeah, it's really important to make this point. We kind of debated about whether to make the points that I'm about to stress, but I think it's appropriate. The violence that we're seeing in schools, shootings, I mean, some of the things that are just out of our control, it's scary, and what we try most hard to deliver when we do our planning is to make sure that we have a plan in place for you that lets you sleep at night. It's about peace and knowing that you've done all you can do for yourself, for your family, and really for your community. So, the fact is that as we talk about tax issues and protecting your wealth, it's not about dollars and money. It's about personal and family and community security. It's not we're not talking about luxury items right now. It's like, what can you do? What can we do to make our individual and community worlds a little bit safer? And sometimes it takes money to do that. Money for security, money for just have confidence that you've taken a few extra steps to see to it that you and your kids and your grandkids and your kids' community, your schools are a little bit safer. And I think we can do something about that. That's a different topic, obviously, but we have to have resources. So we are unapologetic in saying that, one reason to protect assets is to use them in this way that reinforces safety and security in our own worlds.
Absolutely. And what we're going to talk about today can truly change your family's future. These are such critical concepts. Understanding them gives you so much power. And we just want you to imagine what's possible for you, for your children, for your grandchildren, when you take the right steps to protect what you've earned. That's what this is about. So let's go over what we're going to cover here today.
Okay, we've got a number of topics. Much of our focus is going to be on the estate tax. Some people call it a death tax, but it's the amount of tax that may be imposed upon your estate when you pass away. Why you need to be aware. The most obvious reason, of course, is to protect assets, but we'll go through that. Steps you can take to reduce or eliminate estate taxes. We'll identify not all, we can't possibly in our time, but some of the strategies and mostly to empower you. Prop 19, that's not our primary focus today, but kind of makes the point that when we talk about tax exposure and avoidance, it isn't just estate tax. Prop 19 threatens our family's ability to retain real property, as many of you know. We'll touch on that. Next is the elegant trust, the dynasty trust that can protect your kids, your grandkids from tax exposure, all kinds of worries that we all have. So, it's a question of how we can help. What are the steps that we can take on your behalf and making this very accessible to you?
Yeah, just to be clear, this is for informational, educational purposes. We can't give legal advice to you unless we really know your whole situation. We're formally working with you. So this is meant to educate you about these concepts, but don't try this at home. But we're going to show you how you can do it when you work with the right team. So let's just take a moment. For those of you who don't know our firm, Gilfix and LaPole, that's who we are. We are proud of our heritage, and we are proud to be national leaders in the estate planning and elder law fields. We regularly publish articles. We're in the media a lot. We publish books. Mike was really the founder, along with my mom, Myra Gerson Gilfix, of the field of elder law. He created America's first free legal aid program for the elderly in 1973. SALA still exists to this day. And really created the field of elder law in doing that, served thousands of older Americans with free legal services and created programs all around the country working with partners. So that's really what our firm came out of. And I'm personally very proud of that because it's my family. And we're proud of our legacy here in Palo Alto. We've been here for over 38 years. We serve people throughout the state of California, from San Diego to Wairika. And our goal is always to provide extraordinary value and peace of mind. That's what it's about. And it's not just Mike and I. We just want to let you know, Nick Klingenberg, Renee Conrad, Francis LaPaul, we have an exceptional team. We're very proud of that. And we all work together. So it's not just Mike and I. We have a wonderful team, and we all work together as a team. Whenever we're dealing with these concepts we're talking about, we come together to figure out the best approach. And last background point here, but we've literally written a book on this. I shouldn't say we, Mike literally wrote Beat Estate Tax Forever. It's available on Amazon, actually, and it's available to our clients. If you work with us, we'll give you a copy. But just to make the point, we think about this a lot. We write about it. Mike's published a book about it. So we're passionate about educating families. We want to educate you about this. Now, what are we really focused on here? Well, it's, as we talked about, the death tax. Well, it's actually not a death tax, it's the estate tax. As Mike pointed out before, it's not a tax upon death, it's a tax upon an estate if it exceeds a certain amount when you pass away. And I always like this cartoon because it shows the Grim Reaper getting a tax bill. And hey, if the Grim Reaper would pay my taxes, I'd be very happy. But unfortunately, the Grim Reaper is not going to pay your tax bill. If you have exposure, your family is stuck with that bill. So let's dive into some details about the estate tax and the numbers you need to be aware of.
So first of all, let's take a look at what the law is today. Today, the level of estate tax protection is the highest it's ever been. We did have 1 year where there was no estate tax, but don't think that's not going to happen again. So currently, an individual can pass along over $12 million at your passing or by substantial gift without exposure to gift or estate tax. So for a couple, way over $24 million. Everything over these amounts is taxed at the 40% rate. So, lest you think this means you don't have to worry, in 2026, the level of protection is basically going to be cut in half. Still not insubstantial. $6 million, a little bit more than that per individual. So about maybe $12.5 million for a couple. Could there be changes in law? Of course, any year that could change, but you never think about, we always say, hope is not a plan. You can't say, oh, gee, I hope there'll be more protection. That's crazy. You have to deal with the law as it is today. So 12 million for a couple in a few years. If you own property around here, that's what creates exposure for millions of individuals in California. So your estate is going to grow. We'll go through some logical projections in just a couple of minutes. So the level of estate tax protection is coming down, the value of your estate, notwithstanding the current market. We are optimists, but time tells us that over time it does work. Your home value is going to go up. So, you're on the webinar. So you obviously are thinking about this. You have exposure or potential exposure.
Yeah, and we want you to reframe how you think about this because it's a hard concept to get across. Estate tax planning is an investment. I know we sometimes think about it as, oh, I got to pay a lawyer to do a bunch of stuff. It is one of the most powerful investments you can ever make. I think we're unique in any field where we can show you if you do X, Y, and Z, we can protect millions of dollars from taxes. And a penny saved is a penny earned. If you can help your family avoid paying $1, $2, $3, $4 million in estate taxes, that's the equivalent of earning what, 7 or 8 million? Because it's after tax money. How much do you have to earn to deliver $2 or $3 million in value to your family, right? In California, we're taxed at like 40, 50%. So you have to earn double that. So in some ways, you're saving double the dollars that you are preventing from being taken by the IRS if you face these taxes. So think of this as a return on investment type of process. It's not about just throwing money at something. It's something very unique about this area of planning. We can show you what we can do to protect. And by the way, if you have questions, please use the Q&A function. We're going to try to get to as many as we can at the end, but we won't really be able to get to too many as we go. If you're watching a recording of this, of course, we unfortunately can't answer questions. And what are we going to explore? We're going to look at some tools, and these are tools that ultra high net worth families like Phil Knight and his family, Jeff Bezos, and a bunch of other billionaire families have been using for decades to save hundreds of millions of dollars in their case, sometimes even billions. But there's no reason why it should only be billionaires that get to take advantage of these tools. They're legal. They're accepted. And if you have the right team around you working with you, there's so much we can do. And you do not have to be ultra high net worth for these to be valuable. As we talked about, and as we're going to talk about more, you very well might not think of yourself as high net worth. But when it comes to the IRS, they might consider you high net worth. And if they do, well, then you have some trouble. So that I want you just to reorient how you think about this. We're trying to give you the tools that ultra high net worth families have been using for a long time with teams of advisors.
I want to re-emphasize that changes are coming, not tomorrow, but in the very near future. And so many folks say, oh, gee, you know, it's not tomorrow, we'll wait. We have time, let's not think about it. We all know that delay and inertia, they are our enemies. They are enemies. We delay a little bit, next thing you know, months go by, a couple of years, health problems come up, countless occasions. We have clients where we started doing some work, they pass away or become incapacitated due to a stroke before they finish planning. So you know this intuitively, but you got to drink it in. You got to take an objective look at your situation and meet with us just to explore and then find out what makes the most sense. So let's look at some numbers now and think, the question is, are you, excuse me, are you someone who should think about it? So if you're a single person and your estate's around 5 million, including life insurance, including retirement money, even including money that you might inherit someday, you have exposure as of 2026. You can do something about it now. If you have 10 million or 9 million as a couple, same point. Your estate's going to be growing. The level of estate tax protection is coming down. So objectively, we look at the value of real estate. I mean, it just goes up relentlessly, whether we like it or not. Doubling, I think last year went up 17% around here, 1 year. Okay, so I mean, it's off the chart. So acting now means that not only do you capture value by using some of these tools, but if you remove assets from your estate for the benefit of the next generation, after you do that, the growth in those assets continue for the benefit of the next generation. So yeah, you should worry. You should think about it.
Yeah, and let's talk about growth. I studied management science and engineering in my undergrad days at Stanford. So I did a lot of projection work and I figured out, you know, how to use Excel and all that. But it's actually, you don't need to study engineering or be a math genius to understand that your estate's going to grow, almost certainly. So where you are today is not where you're going to be in 5 or 10 years, even if you're not necessarily earning that much, just holding assets. If you're smart enough, just hold on to your house and not dig into your investments. I know we're in a bit of a bear market now, but historically we come out of those. And so let's just look at $1 million. If you invest it over time, if you get 12% returns, it doubles every 6 years. If you get 5% returns, which I think is pretty reasonable to expect at least 5% returns over time, it doubles every 14 years. And if you get even higher returns, it can double even faster. So the point is, where you are today is not where you're going to be in a few years, where your family is going to be. So you need to think proactively. And we're going to talk about some of the concepts and some of the tools you can use to prevent that exposure ahead of time, tools you can use right now. So let's talk about a fairly straightforward example of transferring
you know, these numbers are going to be pretty precise just to make the point. Okay, here's a very fortunate individual, Susan. Her estate is currently valued at a little over $12 million. She can take some steps right now. She can transfer those assets. She can put them into entities that still give her income. It doesn't mean she has to give it all away, but she could take advantage. Here's the point. She could take advantage of the current opportunity to protect $12 million. You don't have to die and pass along $12 million to capture this. You can give it away. It's either avoiding an estate tax or a gift tax. So an individual can give away a little over $12 million right now, take advantage of this exemption and protection. Then she passes away in 2026. There's nothing left in her estate. And how much did we save? Because we avoided this drop in protection to 6 million, almost $2.5 million. This is simple math. It's remarkable. Now, what if she does something different? What if she does take advantage of these opportunities, but not that much? She says, you know, I'm going to give away 6 million. I'm going to give away half. Well, it seems like it's a half step in a way. It is, but it doesn't do her much good. If she gives away 6 million now, she's used up 6 million of her lifetime protection. So come 2026, when it's 6 million, she's used 6 million. You don't get another 6 million. If you use it up by a gift, it's gone. It's exhausted. So again, in her situation, by not taking these steps, she's going to have 6 million exposed to the estate tax, 40%, and she's going to lose again something approaching $2.5 million in estate tax. So you can use it creatively. It's not all or nothing. Some individuals do take these steps with 8 million, 9 million. these are significant numbers, and
Big
not
number.
everybody
No.
has this, but you're on the
No.
webinar, so most of you have these issues, hallelujah, or you have family members who do.
Or you
winning
might in the
strategies.
future. Right. Or maybe your parents do, or grandparents, or maybe
Yeah.
you hope to get there in the future. We want to arm you with that as you get there. And keep in mind, if you save $2.5 million in taxes, that's the equivalent of earning 4 or 5 million, right? Because that's no tax issues. You have to earn 4 or 5 million to get 2.5 million net of taxes. Let's talk about some specific tools. Anybody here familiar with Shawshank Redemption, the movie? I think it's one of the best movies ever made. I won't give any big spoilers here. I can't see your hands if you raise them or anything, so don't worry about it. For those of you familiar with the Shawshank Redemption, you'll get this, and even if not, you'll still get this. So there's a scene in the movie. It's about a very smart guy who's in prison for life, and there's a sadistic prison guard. He's psycho. He threatens all the prisoners and kills a few, all crazy stuff. There's a scene where Andy Dufresne, the protagonist in the movie, overhears the psychotic guard complaining about taxes. And Andy Dufresne then, I think stupidly, says, "Do you trust your wife?" And of course, the prison guard hears him say this and goes over to him and say, "What?" He goes, "What did you say to me? I'm gonna," and he grabs him by the lapels and holds him over a big drop off, and it looks like he's gonna kill him. And Andy Dufresne goes on to say, "Do you trust your wife? Because if you do, I can save you thousands of dollars in taxes." Because Andy Dufresne is an accountant by trade. So I ask you, do you trust your wife? Or do you trust your husband? Because that's what a SLAT, a spousal lifetime access trust, is about. Now let's talk about this very powerful tool. This is one of many. This is just to be illustrative. Even if you can't follow all of this, what I really want to impart to you is what we can do, what this can save. And frankly, how straightforward it is to set this up. So what is a spousal lifetime access trust? One spouse sets up an irrevocable SLAT, spousal lifetime access trust, for the other spouse. So husband for wife, or wife for husband. You can put up to $12.06 million in assets into this trust, and there's no taxes owed. Because remember, we can give away up to $12.06 million. The other spouse then has control of this. The spouse can use it to support the couple. It's not like it's only there to support the spouse for whom the trust is created. It's still there in your family. You haven't even given it away to the next generation. But it takes 12.06 million. It future-proofs your plan. You've taken advantage of the high exemption, and the future growth of the value of those $12.06 million in assets is out of your estate. So over a number of years, that 12 million in that trust could grow to 15 to 20 million. And when you guys pass away, or when the spouse passes away, that goes to the next generation free of estate taxes. So not only have you locked in the higher $12 million exemption, but you've locked in protection for all that growth in the value of those assets. So it's a way of avoiding a minimum, and I mean minimum, of $2.4 million in estate taxes, assuming the exemption goes down to 6 million, as we expect it will, in a few years. Now let's just illustrate this. We're going to look at Fred and Wilma, the Flintstones, versus Homer and Marge, the Simpsons. Let's assume they've done really well. Their shows are very successful. They get royalties. Both have $17 million estates in 2022. That's high net worth. Fred and Wilma, though, take steps before the exemption drops to 6 million a person, and they create a SLAT. Homer and Marge, well, obviously they don't do anything because Homer doesn't do anything. Both couples live another 10 years and their estates grow. We talked about how the value of your assets could grow. They grow to $30 million each because they just don't use up all their money. So what happens to Homer and Marge? So they invest well, their estate grows to 30 million. The exemption goes down to 6 million in a few years. When they pass away, we can protect 6 million per couple. Homer can protect 6, Marge can protect 6. 12 million is protected, but that leaves 18 million of their $30 million estate exposed to a 40% tax. $7.2 million are paid to the IRS in estate taxes. So their kids, I mean, look, their kids are still going to have a lot, but $7 million plus is lost to the IRS. Now let's compare that to Fred and Wilma. So Fred sets up a spousal lifetime access trust for Wilma. He uses his entire $12.06 million exemption. It's there for her. Now they still have $5 million outside of this trust. Again, assets in the spousal lifetime access trust grow over the next few years. They grow to $20 million. Assets outside of the SLAT also grow. They grow to 10 million. So same position as Homer and Marge, a $30 million estate. The exemption drops in 2026. Now what happens here though? Fred and Wilma, because they set up this trust, that full $20 million in the Spousal Lifetime Access Trust is protected. Not a penny is lost to the IRS. Now, they do have some other assets that are exposed to estate taxes because maybe they didn't plan, although there are other steps they could take for that $5 million outside of their trust. Bottom line, they save over $5.5 million for their kids, their grandkids, and their great-grandkids. $5.5 million saved by simply setting up a Spousal Lifetime Access Trust. You don't need to understand all the details here. I know I went through a lot. You just need to understand how powerful these tools are. And this is one of several tools. And Mike's going to now talk about another type of tool that is available to save millions in taxes.
So there are so many tools available. I identify almost all of them in my book about estate tax planning. One is an LLC. Many of you are familiar with the LLC because you use it for rental property. It's got sort of some asset protection benefits, but now we're going to talk about how it can be utilized to reduce estate tax exposure. And it's a concept of discounting. So the idea here is you take an asset that is in your estate and you put it into an LLC. And what you do at that time is you discount the value of the assets that you're transferring because you, the parent, can keep control. You might be in charge of the LLC. And because the owners of the LLC, perhaps your kids, don't have any control, they have ownership but not control, right? They can't demand a distribution. We can very significantly discount the value of that gift. We say 20%, that's actually, I'd call that a minimum discount, not a maximum. I would change our phrasing here going forward. So what we're doing here is we're transferring, in this example, $14 million worth of assets, which seems like it's too much for an individual because it's over 12 million, but it isn't because we're taking that discount that reduces it to a gift value of well under $12 million. By this example, given what the future of the estate tax will be, we just saved over $3 million in estate taxes. So LLCs, again, are one of many tools that enable us to use the concept of discounting to make some significant portion of the estate disappear because of the structure that you use and the way that you put it together. LLCs can be used in many, many different ways. By the way, this is a very simplified example. The approach that may make sense for you is going to completely depend on the nature of your assets and a number of other factors that would have to be discussed. What else? What are some other strategies that we might also?
And I apologize, there's more detail here than I meant to have. These are just many, many different examples. So Mike, sorry, go ahead.
Okay, so again, many strategies. No way we're going to go through all of these. I think I'll just mention two just for the moment. One is something called this personal residence trust. So with the idea, so if you have a taxable estate and your home is worth $4 million and you make a gift of it to your kids right now, it's a gift valued at $4 million and you're using up $4 million worth of your estate tax protection. Lots of reasons why you might not want to do this, but you could. You get it out of your estate. If you instead use this trust, the trust is structured so that there's a delay between the date on which you transfer the house into the trust and the date when your kids get it. They have to wait many years before they become owners. So because of that delay, the value of the gift that you make today is not as big as it seems because they have to wait so many years. So again, we can discount the value of that gift depending on the term, 20%, 40%, sometimes 50%. And if we did that, the value of that gift of the $4 million house, the value of the gift might only be $2 million. So we're making $2 million of the estate disappear right off the top. And then again, we're removing the growth and the value of that asset from our estate for as many years as that term exists. So again, saving small fortunes. Life insurance is tricky. If you have life insurance, you've probably been told that life insurance is tax-free. The distribution is tax-free. So if you have a $2 million policy, true, there's no income tax there, but the $2 million is part of your taxable estate. Very important. Now, if instead that policy is owned by an irrevocable life insurance trust, the death benefit is not part of your taxable estate. So, simple math tells you that that could save a small fortune. It has to be structured properly, many steps to take, many considerations. But again, you just have to be aware. Okay. Now, whenever we talk about gifting and planning steps that you might take, we have to talk for a moment about foundations, charitable giving that you might undertake on behalf of any issue that is of concern to you. So let's take a look at foundations for just a moment. Okay, the idea here is to create a family foundation, transfer assets into it. When properly structured, the gift that you make is tax deductible. You're removing assets from your taxable estate, putting it into a foundation that will pursue the purposes and objectives that are important to you. One of the reasons we love it so much is that it is a family legacy. The kids get involved, the grandkids get involved. Somebody can take a salary, by the way, for working at it. But if you have an issue of concern, and rather than making charitable gifts to another entity, which is a perfectly fine thing to do, this is a way of making significant charitable gifts and keeping control within the family. Values are pursued and reinforced on so many levels. So, we always want to think about that as one of the many strategies that are incorporated. We've probably set up about 15, 20 such family foundations. It's a wonderful thing, a wonderful family legacy.
Yeah, and one other tool that I want to just flag, a
Sorry.
lot of our clients are doing now, and this is actually, we had this earlier, this actually is a picture of me with my grandfather Joe and my mom and my step grandmother. So this is about the grandkids. So Mike, why don't you talk about this, because you now are a grandfather.
Yeah, this is my favorite trust, and I forgot to mention it. So sorry. Okay, so a crummy trust. Okay. I call it the grandparents' delight. So you have grandkids. You love those grandkids. They're perfect. They haven't had time to screw up yet. So you still think they're absolutely perfect. You want to set aside some money for them. 529 plans are not a bad idea. Uniform transfer to minor act accounts where they get the money at age 18, usually not a good idea.
I've had 3 calls this week about people panicking about a kid turning 18 with those accounts. Not a good idea.
Getting $2 million. Okay, so the idea here is you set up this trust. You can fund it, each of you, using the $16,000 annual exclusion. So if you're a couple, you can put $32,000 a year into a trust for each of the grandkids. And the point is this: they don't get the money at age 18. You decide when and if they get the money. You can say they don't get this money until they're 30, 35. You can, usually the parent would be the trustee. The money can be used liberally, not just for education, for health, for housing. And look at the cost of housing around here. Not a bad idea to use some of that money to help a kid make a down payment on a house. So again, this is a way of helping out the kids, letting them know you're doing it now. The grandkids, let them be grateful now rather than just leaving something when you pass. So they're called crummy trusts after a court case. It's not a characterization.
Yeah.
Write this one down. It's featured in my book. It's a wonderful, wonderful planning tool, grandparent to grandchild in particular.
And it's very simple too. I'll just reiterate that you're just using every year. This is a different set of rules. We talked about the estate tax exemption, 12.06 million. Independent of that, you can give up to $16,000 per year to as many people as you want, and you don't have to report that to the IRS. It's kind of a get out of jail free amount that you can use to help out family members and to reduce the size of your taxable estate. So these are all about using that $16,000 a year exemption for each of your grandkids and giving your kids, their parents, control, as Mike said. So a wonderful and pretty straightforward tool. We've set up a lot of crummy trusts for families in the last couple of years. And let's kind of bring this all together here. We talked about so many different concepts. There is no one size fits all approach. Think of us as your team that helps you come up with this integrated structure. We use combinations of these tools to reduce or eliminate estate tax exposure, but ideally you want an integrated estate and financial plan, an integrated team. Think of us as the designers of your plan, and we're going to pick and choose different tools based on your goals, your concerns, and your dreams, frankly, because there's so much that we can achieve when we use these tools. So again, there's no one size fits all approach. And that's where we just need to get to know you and get to know your situation to begin to develop that plan. So a lot we threw at you. It's okay if you didn't understand all these concepts, but these are all tools that we have available. Now let's talk about Prop 19 and why that's important.
And this is important whether you have a very large taxable estate or not. If you're a homeowner, if you own real property, we just have to mention this. This is not estate tax, but we'd be derelict to not mention this, every time we do a webinar, because it is so significant. It complicates everything. Okay, before Prop 19, which became law last year, this is the law in California. Your residence, and one or maybe two other properties that you own could have been passed along to your kids with no property tax increase. That's gone. That was Prop 58. That was Proposition 58. Gone, gone. Now we're looking at reassessments, property taxes dramatically increasing at your passing if your kids want to keep the property in the family. Okay, now the Blessed San Jose Mercury published 2 articles saying that if your kid lives in your residence, there's no property tax increase. That is absolutely wrong. There is some protection if and only if a child makes your residence her residence. Then the first $1 million in reassessed value is protected, but only $1 million. So if you're now paying $8,000 in property tax and your home is worth $4 million, if your kid lives in it, if it's worth $4 million, $1 million is reduced, it's going to be reassessed at $3 million. So the property taxes are still going to go up to about $34,000, $35,000. I mean, you got that number, like $34,000, $35,000 in that example. If your child does not live in the residence, there's no protection whatsoever. So if that house is worth $4 million, property taxes will go from 5, 6, 7, or $8 million, $4 million up to $45,000 per year. Rental property, second homes, no protection whatsoever, no exceptions, complete reassessment. So, you do the math. Your kid lives 25 years after you pass at another $20,000, $30,000 per year. That can eliminate the ability of the kids to retain the property. We got hundreds of thousands, millions of dollars are at stake. So as you may know from other webinars that we've done, we have developed tools to avoid this outcome. This is as important as estate tax planning. Our job for you is to coordinate and integrate these planning tools. Got to be careful that you don't take one step for one type of tax and trip over the other.
And we talked about, again, the power of planning. We've helped a couple hundred families with Prop 19 planning already. We've developed some really powerful tools. And right now, kind of calling it the Gilfix and Lepole Dynasty LLC. If you have questions about this, we have a webinar that we gave last week. It's on the Gilfix Law YouTube channel. You can check that out if you want to dive into that more. And of course, we can chat with you one-on-one to really dive into that. But the tools that we have can save hundreds of thousands of dollars. And just the last note there was an attempt to overturn Prop 19, to repeal it. And it was an attempt to put it on the ballot this fall, and they fell well short in the number of signatures. They weren't even close. So it is the law, and it will be the law for the next few years, if not indefinitely. So you have to be aware of this. There are tools available. So let's make it one last transition here. We've talked about all these sophisticated estate tax planning tools. We've talked about Prop 19. Now, this is a tool that whether or not you are ultra high net worth or high net worth, whether or not you're worried about estate taxes for yourself, a tool that you need to have in place for your kids and especially for your grandkids. A family protection trust. It is our version, the Gilfix and Lepole version of what is generically known as a dynasty trust or a generation skipping tax type trust. There's a lot of different terms, but if you Google the term dynasty trust, you'll see a lot out there about this. Now, what am I talking about? So the tax planning issues we talked about, those tools, they can all be integrated with this, but even if you decide not to do estate tax planning, your core estate plan, your living trust, you should not leave money directly to your kids. Instead, you should leave money to trust. Now, why would you do this? If you have 2 kids, you create 2 family protection trusts, one for your first child, one for your second child. Why would you do this? Why wouldn't you just leave money to your kids directly? 3 big reasons. 1, divorces happen. If you leave assets to your child directly and they commingle them at all, they could get lost in a divorce. If you leave it to a family protection trust, those assets are separate. They should not be touched in a divorce settlement with that ex-spouse that you never liked anyway. 2, if your child is sued, if they inherit money directly, that's all exposed in a lawsuit. If they're in a car accident or a bad business deal, we live in a litigious society. If it's in a family protection trust, there's a barrier. There's some protection. Someone has to break the trust to get access to that money. It's a huge deterrent for someone going after your child's inheritance. And 3, when your child passes away, and especially if you have grandkids already, or if you think you'll have future grandkids, the assets in this trust are protected from estate taxes. So let's say your child inherits $1 million, $2 million, or a house in this area, $3 million worth of assets. During their life, again, we talked about how much that can grow during their life. So what you might think is not that much money in the context of estate taxes now Well, let's look 20, 30 years in the future. We don't know what estate tax laws will be. We don't know how much the value is going to grow. But 30, 40, 50% of what you leave your child could be lost in estate taxes before it gets to the grandkids, unless you create a family protection trust. Assets in the trust, subject to some limitations, are not part of your child's taxable estate. The assets grow in value untouched by estate taxes when they go from your child to your grandkids. And that's where, even if you don't have a huge estate now, if you just own a house in this area, we are talking about potentially millions of dollars in savings for grandkids. And you might think, okay, this is great, Mark, but that sounds really complicated. I don't want to tie my kids' hands. Well, if you think your child is responsible and can manage this well, they can be the trustee of their own trust after you're gone. So you can still give them the power to oversee these assets and use them largely as they see fit to support their family with all these incredible protections. So it's just an extraordinary trust that is a very elegant tool. The vast majority of the clients we work with, when they're just updating their core estate plan, updating their revocable living trust, most will add family protection trusts for their kids. And we can do that for you. And of course, we can integrate that with the rest of your plan. And it's in the news.
Yeah, dynasty trusts are no secret. It's a matter of folks who are immensely wealthy, maybe being put off by the term dynasty trust. It's appropriate for anybody who owns any property around here, not just for the mega wealthy. This, by the way, is a quote from an NPR report. That's how wealthy people avoid estate tax, protect assets for future generations. So it should be mainstream. Unfortunately, it isn't, but for our client community, it is. We believe the bottom line here, that it's crazy not to do it. The exception, by the way, is if you have a kid with special needs, and then of course we do a special needs trust. But if not, it's the dynasty trust. It makes no sense to avoid taking this step.
So again, we've gone over a lot of tools. You are now empowered with an understanding of the tools that are available. It's okay if you don't understand how these all fit together. That's what we do. There's no one size fits all solution for every family. We have to weigh capital gains tax concerns, property tax concerns, of course, Prop 19, your personal goals and concerns. We have to be thoughtful about protecting assets for future generations. And just to be clear, not as we say here, and as Mike said earlier, not everything is about tax, not everything is about maximizing wealth, but knowledge is power, and you worked hard for your assets. And we want to empower you with the ability to protect that to the best extent possible as allowed by the law for future generations. And there is so much that we can do. And it's our job to meet with you and figure that out. So we're going to wrap this up shortly and tie this all together even more. Mike alluded to this, but if you have a child with a disability, or if you know somebody who has a family member with a disability, they need to do a special needs trust. We've written a book on this, Special Needs Trust Creation and Management Guide. Next week, on June 1st, we're going to be offering a free special needs trust webinar at 1 p.m. and 6 p.m. That will also be on our Gilfix Law YouTube channel if you're watching this as a recording. Spread the word, let people know special needs planning is something we're passionate about. And of course, if you have a child with special needs, well, protecting your assets is also crucially important as well. So, you want to make sure that child has a financial safety net. So don't lose this opportunity. Right now, you have these concepts top of mind. You're thinking about this. Inertia is the enemy. So we invite you to meet with us. We can review your existing plan. We can discuss your goals and your issues, and we can develop a step-by-step plan for you. And we can lock in millions of dollars in protection now, and we can usually retain a lot of flexibility going forward. It's not like if you take a bunch of steps now that you're giving up the ability to change your plan in the future. Some steps are pretty restrictive, but there's a lot that we can do now to just situate you very well to protect assets in the future. So we, of course, invite you to meet with us. Our meeting availability is always limited, but we invite you to contact our office if you'd like to make a meeting. You can contact us at 650-493-8070. You can contact Nadia at gilfix.com. She's going to be handling inquiries from this. And if you want us to reach out to you, you can enter your name and contact information in the chat function or even the Q&A function. We can try to get those, and we'll take it down, and our team will reach out to you. So we, of course, would love to get the chance to work with you and to meet with you and to get to know you and understand your goals and concerns. Now, if you don't know our firm, we typically are happy to offer a 10 or 15 minute Q&A discussion just to get to know how we do things. We want to make a special offer here for those of you viewing this webinar live. We're actually going to edit this out of what we post online. If you have not worked with us in the past, if you're a new client, you haven't worked with us, we want to offer a 30-minute complimentary getting to know us meeting. So if you haven't worked with us before, we would love to get the chance to get to know you. So let us know, mention that you attended the webinar live. We can contact Nadia or in the information here, and we will set up a Zoom or in-person meeting with you. No strings attached, just to get to know you and your situation, see how we can help you for 30 minutes at no charge. If you want to keep going, typically our planning meetings, we bill at our hourly rate because we're there to serve you from day one. We're not there just to consult and sell you on moving forward. And in that 30 minutes, you can stop it then and we can set a follow-up, or you don't have to do anything after that. If you want to continue that meeting to complete a plan, we would only bill for time beyond that. So this is something we don't typically offer, but we know you often need that just extra push to get started in the planning. So if you haven't worked with us before, just want to get to know us, take advantage of that 30-minute free for new clients offer to get to know us. And if you have worked with us before, let's set a meeting and just dive into this. Anything you want to add here before we get to questions?
No, it just, we always kind of marvel at lots of folks from these webinars come and see us. We worry about folks who don't, who just don't learn more and pursue it to not necessarily implement a full plan, but just learn about the options. Learning about the options, that's where the power is. And I'll go back to what I said earlier about the importance of protecting assets so that we can protect ourselves. I believe that, not only that, but that's a factor these days. It's on my mind. So, I bring that to that consciousness to meetings that we might have. So
yeah, absolutely. Again, it's not about just maximizing wealth. It's about providing security and a financial safety net for your family, for your loved ones, for your kids, for your grandkids, for your great grandkids. And we just know that the families that do this now, that take steps to plan for the future, when we look a generation, 2 generations ahead, those families are going to be in such a better place than the families that don't do this. Assets get lost, taxes hit you, lawsuits hit you, divorces hit you. If we can protect against this, the difference over multiple generations can be extraordinary. So we want you to be on the right side of that, to understand these tools. And whatever you do, I like to say an educated decision is a good one. As long as you know the trade-offs, you're going to make a good decision. So let's get to some questions here. So we have one question about, if you transfer, it's about a spousal lifetime access trust. If you transfer $12 million of appreciated stock into a SLAT, is the transfer viewed as a sale for tax purposes? Do I have to pay capital gains taxes now? And the answer is no, you don't. When you put money into when you put assets into that spousal lifetime access trust, there's no taxes owed. There's no estate or gift taxes because you're keeping it under the $12 million limit. And the only thing is, if those stocks are ever sold within the SLAT, then you would have capital gains taxes would have to be paid. But there's no big tax bill when you put assets into the spousal lifetime access trust.
And a couple of questions pertain to IRAs. Not uncommon in our community for folks to have $1 million, $2 million, $4 million and more in retirement accounts. And those are frankly a little bit challenging because if you take them out of your name, such as transferring them into a SLAT, that's you've taken those assets out of the income tax protected IRA, and all the income tax is going to become due. So you can't just transfer an IRA into a SLAT. You have to be so often IRA money is the best money to use for charitable giving because you, number one, remove it from your taxable estate, and number two, when the entity gets it, they don't have to pay the pent-up income tax. So charitable giving is a factor, other considerations, but large IRAs present some challenges. There are other ways of dealing with them, but not in the context of the SLAT. That just doesn't work.
And good question from Veronica about, can a crummy trust be set up for a great nephew? And does the beneficiary have to be a minor under the age of 18? Mike, why don't you take that?
The beneficiary does not have to be a minor, and it doesn't have to be in your bloodline. I mean, the $16,000 annual exclusion gifts, you can give those to anybody, a relative, a friend, a godchild, a grandniece or grandnephew, anybody. So on countless occasions, folks set them up for a younger person who's not in their strict bloodline, so to speak. So, long way of saying, yes, you can do that.
Absolutely. Now, another question about spousal lifetime access trust. Do they avoid a Prop 19 reassessment when you pass away? And the answer there is no. Spousal lifetime access trust is not designed as a Prop 19 planning tool. There's a very specific process that we've designed to avoid the reassessment. It involves the use of LLCs and entities and the special trust, but a spousal lifetime access trust, unfortunately, does not protect against a Prop 19 reassessment. Yeah. Another question, and we're just going to take like 2 more questions, and then we're going to wrap this up. And one that you, Mike, you wanted to address?
Yeah, one is about why not, I hear you, but why not wait a couple of years, see if the law changes? This drop in protection in 2026, that's not a matter of there being a new law that passed. The current protection is because of a 10-year piece of legislation. So at the end of 2025, that protection evaporates, and then we automatically go back to the level of 6 million per person. So it isn't like there's a new law saying 6 million. It's the fact that current legislation expires, and then we go back by default to where we were. So it isn't an assumption that it's going to go there. It isn't maybe it's going to go there. It's going to go there. The likelihood of a change is so slim, I just wouldn't give it any credence. It's going to happen.
Well, as we like to say, hope is not a strategy. There are millions of dollars at stake. Why not take advantage of what we know is effective right now, rather than waiting to see where the winds of Congress blow, which we can't.
And we did have, I mean, we all hate these horror stories, but we had a gentleman with a very large estate in the 20 millions who started to do some planning, and before he could finish it, he passed away. He had a terrible health development. He never finished, and that, cost mega millions. Now that's not common. We're not trying to scare you, but bad health happens, losing capacity happens. So you just don't want to delay on these things, sort of obviously.
Yeah, same thing. And Veronica had a good comment about, well, there's lawsuits against Prop 19. People are trying to overturn it. Maybe that'll go away. So first, I wouldn't rely on a lawsuit to overturn a voter initiative. That's just the longest of long shots. Now, it could be overturned in another voter initiative. In fact, that's the only way to overturn it. But as we said, they tried it this year. They came up they got less than 50% of the signatures needed. There will probably be other attempts. But again, hope is not a strategy. You don't want to risk millions of dollars based on the whims of a ballot initiative.
Let's not forget that Prop 19 isn't a law. It amended the California Constitution. So your local friendly legislator cannot go carry a piece of legislation and undo this thing. That's why it's going to be so tough to undo. And I would not count on it. There's many folks love this aspect of Prop 19. Teachers unions and public employee unions, they like it because there's more money coming in. Realtors love it, right? Because more homes are going to have to be sold. So powerful forces are in support of this aspect of Prop 19. The likelihood of a change in the near future, I think it's 0. Maybe after 5, 8, 10 years when people feel the pain, maybe then.
Yeah, I might just, but either way, we can't offer any, insider knowledge about whether it might or might not change. What we can offer is tools to prevent the issues no matter what. So if you take steps to plan, and this also goes for estate tax planning. Let's say you take steps and all of a sudden they change the law in a way that's favorable. That, hey, you can leave more money than we thought. Well, you're not really in a worse spot. But if they don't change it, or if it gets way worse, you're in a much better spot. So you can say heads you win, tails you tie. And this is everything you worked hard for your entire life. So, and I know a couple people think you have given your information in the chat function to be contacted. So we're happy to do that. And I'll do one other question about, and John, I see your question, but about it. So I'll get to that really quickly. If 2 siblings inherit a house and one wants to sell and the other doesn't, well, if one wants to sell, they can sell, or the other, they can force their sibling to buy them out. You can get financing for that to do that sometimes, but it's a tricky situation. If someone wants to sell, you can't stop them unless you buy them out at a reasonable valuation. And thank you for the kind notes, John, and a couple other people. We really appreciate it. And the question about fees and how we do that, I think that's a good thing to talk about, how we work with people.
Sure. Okay. There's time along. One last question. As Mark said, when we do our meetings, with the exception of this 30-minute offer for new folks, we charge it's the hourly rate of the attorney with whom you meet. Typically, that meeting is billed hourly, and there's usually some time beyond that. We've mentioned our presumptive flat fees for most of our documents countless times on webinars, so we're on record. For a dynasty trust, for example, it's usually $3,100 to $3,300. One of the best investments you could ever make. For special needs trust, it's typically $2,900. There's so many different approaches we could take for a revocable trust for a couple that there's no one fee. There's 3 or 4 different approaches that are taken for couples, depending on your circumstance, citizenship status, and more. For a single person, a trust, $2,000 to $2,500, that range, unless there's something crazy going on. So again, no documents are ever prepared without us putting into writing what the flat fee is going to be. We don't want surprises either.
Yeah, and when it comes to some of the tax planning concepts we talked about earlier, it's a wide range because different steps require hugely different amounts of analysis and work. So the key is when you meet with us, we're there to serve you, and we will give you a specific cost to move forward and to complete a plan. It's up to you to decide.
And I know in the past when Mr. LaPole has worked with some wealthier folks, he's done a flat fee, just X dollars, and he says, and we'll take care of it. And he puts together a multifaceted plan. Those folks never complain about the fee.
Yeah,
their return on investment is awesome.
Right. I mean, it's amazing. Yeah, and for these steps, for the tax planning, I mean, you only do them if we can show you extraordinary value. And it's, we all pay, financial advisor, they take a small cut every year. Realtors take a small cut when you sell your house. You don't have to write them checks. So they don't have to always necessarily show you the value every time you meet with them. It's on us to show you the value that we can deliver, because you need to hire every time you need to hire us every time you want to work with us. So it's on us to show you the value we can provide. And hopefully this webinar showed you a lot of that. So on that note, I think we're going to wrap things up. Thank you to those. We have a few people who've contacted us to reach out. So we're going to reach out to you guys. You have one last chance to put your information there. You can also reach Nadia@gilfix.com, and you can of course just call our office to set a meeting. So thank you so much. We hope you got a lot out of this. We hope that this empowered you, and please spread the word, subscribe to our channel, share this webinar, let others know about all these tools that are available. And on that note, I hope everybody's staying healthy, sane, and is doing well. It's a privilege to get to connect with you, and we hope to get the chance to work with everybody here.
And may we all have some great knowledge. And we all have good reasons to sleep well at night.
That's right. On that note, take care, everyone. Have a great
Thank you all.
day.
Thank you so much for watching. If you enjoyed it, please share it, like the video, subscribe here, and stay tuned for more free legal estate planning and financial educational videos.